It's my pleasure to introduce our first two presenters. Kim Vu-Dinh is an assistant professor of law at the University of Arkansas at Little Rock, an adjunct faculty member at Clinton School of Public Service, and a clinical teaching fellow at Yale Law School. Dustin Marlan is an assistant professor at the University of Massachusetts School of Law, where he teaches intellectual property, business law, and directs their community development clinic.
I want to thank everyone. I'm incredibly honored to be here. I am not an IP attorney. Normally I do some trademarks in my clinic, but I am really a clinician. And thanks to Dustin, I was able to pull this article off that is derived from a real problem that I encountered in clinic. I have my client's permission to write about it and to discuss it, et cetera, et cetera. But I'm super honored to be here and intimidated. So please humor me for any kind of foibles I might be tripping on over this throughout this presentation. And I'll go ahead and let Dustin say hi as well.
Roundtable discussion. I do write about IP matters. I write about trademarks normally and the right of publicity. So these patent and copyright issues are somewhat far afield for me too. So I'm really excited to get everyone's input. I just think this topic is too important to ignore. And so I think Kim's going to start and I'm going to conclude the presentation, and Kim's going to try to tackle the more patent-esque aspects of this, and then I'm going to handle the copyright issues.
So I don't think I need to go too far into the reality we've all been dealing with in the past 6 months. To the extent that it pertains to my client, things moved so quickly. And my client is a micro manufacturing nonprofit. And so many people were trying to address, things that were going on in the hospital, a mile or two up the road, without a lot of guidance. The White House was particularly slow to react, and its reactions came in the form of an issuance and of an emergency use authorization, creating some liability shields for makers. But these were primarily focused for those who are professional makers of PPE. And then they also used the DPA, the Defense Production Act, which was in the news a bunch, ordering 6 companies to create a limited amount of things, patient monitors, CTs, hospital beds, but not exactly some types of face masks for hospital use. But these companies were already in the process of of maxing out their potential and trying to do more, and only 6 of them. So these shortages of PPE, of basic stuff that actually has real impact on infection, like hospital gowns, face masks, face shields, small pieces on ventilators, these were still in shortage, and many of these items actually still are in shortage today. So this article is focusing on primarily low cost, easily reproduced items. we're not even going to touch pharmaceuticals because there's just so much law behind that is pretty separate from an immediate problem it's low-hanging fruit. It's low-hanging fruit that a lot of folks, normal everyday folks, can help out with. And I think it's a separate legal conversation to discuss pharmaceuticals and patents on pharmaceuticals. Some of these defendants across the nation came in the form of high school students, individuals, nonprofits, even like super high-end fashion designers in New York were, turning all their sewing machines into face mask assembly lines. the distributors took form of nonprofits, and even nonprofit hospitals were handing out plans for various PPE and other medical equipment, pretty much begging people to do what they can to help them out. The distribution was coming through a lot of folks, just individual folks, tech savvy people, started nonprofits to try and create something of a switchboard in order to distribute items to where they're needed. So the obvious IP issues were blueprints for inventions, exact copies that were being reproduced with 3D printers. And then in copyright, circulation of manuals for equipment, circulation of educational materials. I mean, this is just obviously a sample of the various potential infringements that were occurring or had been occurring. And let me do this. Oh, sorry. Let me move the Zoom. Okay. So we looked at various proposed and existing protections. And one that is still, it's just a bill, is the Facilitating Innovation to Fight Coronavirus bill. So this was drafted really shortly after the CARES Act was passed, which indicates to me that it was obviously a discussion during CARES, but there wasn't enough consensus on it. And it very much is controversial and not very popular on both sides of the political spectrum. And essentially, it talks about suspending patent rights during the pandemic and as a reward, adding 10 years to the patent period. It's really vague. It's 3 pages. It's like 3 double-spaced pages. So it's not super descriptive, and it doesn't seem to be going anywhere at the current time. There are some liability shields under the PrEP Act that was kind of stapled onto the CARES Act. But again, it's not super descriptive, and it looks like and has been interpreted by incredibly sophisticated IP practitioners as really focusing on creating liability shields for manufacturers and end users such as hospitals, where equipment is already undergoing FDA approval, or they're already familiar with the process in some form or fashion, or are prepared to start the process, the FDA process. And then there is an existing kind of overarching provision in our laws, or a possibility. So the TRIPS Act, which is like not a perfect acronym, but they call it TRIPS Act anyhow. It's trade-related aspects of intellectual property rights. It's something that has been signed by every member nation in the WTO, and it basically says, okay, your country can create a compulsory license, and we all agree. And it does not require, the TRIPS Act doesn't say you have to, it says everyone who signs this can. But even in that process, before violating the patent, there must be an attempt to ask for permission unless there's an emergency. And there is a fee that can be disputed. So we use in this country compulsory licenses all the time in music. So my background, I have as like a hobby, I have a record label, and all my artists pretty much like cover music of dead, really old music. And it's super common. Like, I didn't realize until I had this problem in front of me how rare compulsory licenses are in patent. I mean, every musician who does a cover gets a compulsory license. And as a fun tidbit, apparently Prince really hated that. He didn't like having to let people do covers of his song. But in patent, it's much more limited. In Europe, it's much more accepted to think about compulsory licenses for pharmaceuticals, but super rare in the US, and the government has frequently issued a public statement on that. Essentially, it's used for some plant varieties, and other things related to fiber and feed and some food related stuff. We also have an ability through the BAYH-DOLE Act called Martian rights, which enables the US to take over a patent through and pay a compulsory license if the US government paid something into the R&D of that patent. Okay, so it's never been used before. Once there was a threat, a vague threat by Tommy Thompson, by the DHS secretary, to use it against Bayer to break the article talked about, quote unquote, breaking the Cipro patent to deal with or prepare to deal with the anthrax scare in 2005. But the authority under which this potential breaking of patent wasn't really clear. It looked like there was going to be a claim possibly on Martian rights. And the US has been so stalwart about not using Martian rights that it's been criticized for its, for kind of resisting the compulsory license of treatments, HIV/AIDS treatments that were needed in South Africa. And I mentioned the DPA before, just kind of a brief overview. It actually gives the president a lot of different authority that hasn't been used yet. So the president can require private sector manufacturers to prioritize government orders, set out production and distribution, and order companies to recalibrate their factories. And there has been a lot of discussion like, oh, I mean, the president compared us to being like Venezuela if he used it. But in reality, DPA is used by some estimates 300,000 times a year for military equipment. And unlike the War Powers Act, there doesn't need to be a declaration of war. It can just be to prepare for some type of potential disaster. This has been the first time it has ever been used in a public health emergency. So some solutions that practitioners have thrown out there have included created an like a due diligence process. So getting an IP clearance from the IP holder, or just if you can't do that, researching the IP asserted to figure out who owns it and to make sure there is no owner, it is truly open source. And also requiring the third party who needs or who's using the PPE to supply all the info it possesses, just to supply all the info it possesses about relevant IP and infringement risks. Also creative licensing, where again, and patent pooling, where people are supposed to be negotiating these pretty sophisticated agreements with the IP holders, or creating contractual language, so disclaimers on each package, and also negotiating indemnity language between hospitals and whoever it is producing this. So, for sure, that's not happening in the high school in DC that's using their 3D printers to create face shields, right? And so while these solutions are super practical, and a lot of them, like the disclaimer language is fairly easy to get, there's still problems. Like folks are getting plans off of the Creative Commons, the open source source, but without a proper TEAS search, without a proper search of the USPTO website database, like you don't know if it violates a prior art. Like that person who made it might think it is theirs to own in total oblivion of the fact that it's violating someone else's work. So these solutions that thus far we've discussed are, either they require a pretty proactive and coordinated executive branch and its agencies, or they require a pretty high capacity from a micro manufacturer and access to pretty sophisticated legal resources, and they require a lot of time. And, with the statistics I just threw up in the first slide, the virus, obviously, we all know, has been evolving incredibly quickly. So, I obviously didn't have a lot of good news to tell my client, but, Dustin was kind enough to humor me over the phone, like, well, what could occur? And so doing some legal research, some other proposals have been trying to invoke the right to repair. So enabling folks who purchase something to repair it on their own without having to go to the original seller. So often that's used in cars. You don't have to use all parts issued by Ford to fix the transmission. Sorry, that's a personal heartbreaking story. But, you can just kind of use what the mechanic is suggesting. And the idea is for like these ventilators that have these missing parts, you can just reproduce them with the 3D printer without violating any patent. So that works for some of the pieces we talked about. Also, Dustin went to his faculty's workshop and someone threw out there, and I think it's a great idea, Marching rights by proxy and DPA by proxy. So where marching rights and DPA are clearly justifiable, enable kind of a third party person who is behaving in the fashion of a good Samaritan. You could even look at, are they even making money off of this? If they are, you could issue a compulsory licensing, but really looking to see if there is the legal authority for those two doctrines to be used to create a proxy, sort of like a citizen's arrest kind of concept. And then a lot of tort and property law doctrines that could be extended to IP. And then I'm going to let Dustin go into those because they could apply both to patent and to copyright. Dustin?
Yeah, thanks, Kim. So I think in addition to patent, there is a heightened need for free use of copyrighted materials during the pandemic, and I think if you look at for example the free IP pledge that's going on right now, you see, I think most of the IP that's talked about is patent related, but certain things, manuals, blueprints, data sets, technical drawings. Consider an instruction manual to construct a low-cost outdoor shelter for healthcare workers, technical drawings for an outdoor grocery store setup that encourages social distancing, Bing search results relating to the spread and containment of the pandemic. And then you also have in the context of education, it's a hot button issue right now. I know personally I have several students who say, I don't have access to my textbooks. I didn't intend to be in North Carolina right now. I intended to be in Dartmouth, Massachusetts, so I don't have my physical copies of my textbooks. Could you scan me the readings? Recordings on Zoom often contain audio visual materials in addition to lectures, YouTube videos, musics, photographs, in addition to the lectures. So what are the possible solutions here? One would be flexible licenses, and this would could you hit the slide, Kim, since you have control over the deck? So certain authors and publishers have extended permission in the form of flexible licenses to use certain materials, college textbooks, children's books like J.K. Rowling has allowed free use of her books to be read to children, and these are helpful in certain isolated instances. But really, what we need is a declaration holding that use in terms of the pandemic for needed copyright materials or even luxury items. It might make sense. Children's books is not absolutely essential. No one's going to perish if they don't have Harry Potter. but it is a nice comfort, I think, to allow something like that. So perhaps the fair use doctrine would be applicable here as sort of copyright safety valve. You hit the slide again, Kim. So this is a four-factor test. The problem with fair use, though, even though it may be friendly to uses of copyrighted materials in a pandemic, you don't know ahead of time whether something is going to be declared fair use until a litigation were to actually commence. And there's been talk about trying to, establish fair use boards. I know Michael Carroll wrote a really good article called Fixing Fair Use back in 2007 about trying to get, an ex ante certainty over whether a use is fair or not. So, I mean, our thought is sort of beyond fair use, that we need to draw analogy of IP to real property and tangible items in holding that perhaps, these are issues that, like the common law allows certain exceptions to property rights in times of emergency through its Good Samaritan doctrine. Can you hit the slide, please, Kim? Through its exception to trespass in terms of public necessity, and now we're seeing in terms of landlord-tenant law, moratoriums on evictions, and perhaps IP rights too can take the form of needed exceptions in an emergency, like these doctrines do as to real property rights. And my thought is here, IP is built on an economic incentives rationale, and in a time of emergency, individual IP rights may need to yield to collective interests here. And perhaps for that reason, we should allow emergency exceptions along the lines of these Good Samaritan laws or public necessity or landlord-tenant law. And perhaps a statutory exemption might be helpful here as an overarching solution. So I'll stop there and turn it over to questions or comments. Thanks, everyone.
Okay, so we have a little bit of time here left for questions. If anybody has them, again, if you just want to send those to me in the chat, then I can moderate those. I have a question about Kim's Ford situation, but maybe that's not for today.
It's touchy. It's very touchy right now.
It sounded like it.
Let's just say transmission. It's just.
That's a word that strikes fear into everybody's hearts. Oh, okay, we have a question coming in about what, if you're allowed to talk about this, Kim, about what happened to your client in the end.
I made it really clear the liability on the IP, and he's very well supported by a board, and they're all incredibly they're very much an Arkansas nonprofit. It's there was like a rogue Rockefeller who started a Rockefeller Foundation in Arkansas that's just for Arkansas. So they were comfortable taking on the liability that, I made clear could be an issue.
Okay. It looks like we have another question about COVID vaccines and whether you both think there's likely to be research and development protections for pharma and distribution, or if there might be some type of public interest that is going to interfere there. I know you mentioned pharmaceuticals is like a whole other thing, but.
Yeah, I did dedicate like 3 lines to it. There have definitely been articles saying that's just gonna hurt us. And the history, not just this administration, but previous administrations, I mean, honestly, the way you read their pronouncements really makes it clear that they feel that it's US rights that would be lost. In other words, like, we're the ones making all the hot drugs, right? That definitely seems to be the tenor of these pronouncements. And they, the government has made no change in culture about about its position on violation of pharmaceutical patents.
Okay. We have another question here that just says, go UMass. So Dustin, I don't know if that's for you. But then another one that says, what are some of the proposals for these fair use boards that you talked about, and kind of what do those look like? And this will probably be our last one before we switch, but if you want to address that.
Yeah, so I mean, one thing that we put in our paper that I didn't mention is that there was a statement by a group of copyright specialists holding that educational uses should be, in an open letter, a fair use, and they marched through the 4 fair use factors, such as whether it's a transformational use or not, whether it's in the public interest, whether it's a commercial versus a non-commercial or educational use, and that's should be held fair use. But the problem with fair use more generally is that you just don't know. It's a risk going forward. As a transactional lawyer, what I will tell my clients is, well, we can sort of think about whether your use is fair use, and we can follow certain guidelines that would make it more likely, such as don't use the entirety of the work, use a small portion. But until a dispute actually arises, we don't know. So as an academic matter, Michael Carroll, I proposed something novel, that instead of waiting until the litigation, that there should be these administrative hearings across the country that could hold something as a fair use before actually getting into a contentious matter, that you should be able to appeal to some sort of authority who would hold your use of a copyright as being a fair use, and then you would be allowed to proceed without much risk. But that was, something that gained some traction in the academic world. We still don't have that 13 years later.